Florida's Stand Your Ground law. What is it? What does it do? And when does it apply? Be sure to stick around to find out. Hello everyone, and welcome to the Firearm Firm channel. I'm attorney James Phillips, a founding partner of Katz & Phillips PA, also known as the Firearm Firm, and co-author of Florida Gun Law, Armed and Educated, now in its 5th edition. Before we get into Florida's Stand Your Ground and Self-Defense law, please take a second to hit the like button, and as always, be sure to become a subscriber of the Firearm Firm channel by clicking the subscribe icon down below in the right-hand corner of this video. Now, everyone who concealed carries for protection in Florida must be familiar with Florida's self-defense laws, which include Florida's Stand Your Ground law. In 2005, Florida became the nation's first state to create and enact Stand Your Ground law. The principle behind it is real simple. A person does not have a duty to retreat before using defensive force. Florida's first version of Stand Your Ground law is found in Florida Statute 776.013, subsection 3, and read, "A person who is not engaged in an unlawful activity and who is attacked in any other place where he or she has a right to be has no duty to retreat and has the right to stand his or her ground and meet force with force, including deadly force if he or she reasonably believes it is necessary to do so to prevent death or great bodily harm to himself or herself or another, or to prevent the commission of a forcible felony." Florida's Stand Your Ground law was modified in 2014 and then again in 2018. Now, Stand Your Ground language can be found in 3 different statutes. The first one is Florida Statute 776.012. This is our use or threatened use of force statute in defense of person, and it covers both non-deadly and deadly force. Subsection 1 allows a person to use or threaten to use force except deadly force against another when it is reasonable to believe that such conduct is necessary to defend oneself or another, including a complete stranger, against the other's imminent use of unlawful force. This subsection goes on to read, "A person who uses or threatens to use force in accordance with this subsection does not have a duty to retreat before using or threatening to use such force." As you can see, this subsection does not specifically use Stand Your Ground language, but instead uses the phrase "no duty to retreat." Subsection 2 of Florida Statute 776.012 lays out when a person is justified in using or threatening to use deadly force and contains Stand Your Ground language. Now, under subsection 2, a person is justified in using or threatening to use deadly force under 2 circumstances. The first is if he or she reasonably believes that using or threatening to use such force is necessary to prevent imminent death or great bodily harm to himself or herself or another. A person is also justified in using or threatening to use deadly force if he or she reasonably believes such force is necessary to prevent the imminent commission of a forcible felony as defined in Florida Statute 776.08. Here's a quick list of forcible felonies, and I will also put a link to the forcible felony statute along with all other statutes discussed today down in the description section of this video. Now, unlike subsection 1, this subsection includes the Stand Your Ground terminology and reads, "A person who uses or threatens to use deadly force in accordance with this subsection does not have a duty to retreat and has a right to stand his or her ground if the person using or threatening to use the deadly force is not engaged in criminal activity and is in a place where he or she has the right to be." It is important to note that just like the 2005 version, Florida's current version of Stand Your Ground does have limitations. In order to stand your ground and use or threaten to use deadly force, you cannot be engaged in criminal activity and you cannot be in a place where you do not have the right to be. So the next statute containing Stand Your Ground language is Florida Statute 776.013, which is commonly referred to as Florida's Castle Doctrine. Subsection 1 of 776.013 reads, "A person who is in a dwelling or residence in which the person has a right to be has no duty to retreat and has the right to stand his or her ground and use or threaten to use 1. Non-deadly force against another when and to the extent that person reasonably believes that such conduct is necessary to defend himself or herself or another against the other's imminent use of unlawful force. Or number 2, deadly force if he or she reasonably believes that using or threatening to use such force is necessary to prevent imminent death or great bodily harm to himself or herself or another, or to prevent the imminent commission of a forcible felony." As you can tell from the language of this statute, the statute is limited to a person who is lawfully in a dwelling or residence. Now, there's a lot more to the Castle Doctrine, but I'm going to save that for another video. The last stand your ground statute we're going to discuss deals with the protection of property and can be found in Florida Statute 776.031. This statute has the exact same stand your ground language as we discussed in the first statute, Florida Statute 776.012. Subsection 1 of 776.031 allows a person to use or threaten to use force except deadly force against another when and to the extent that person reasonably believes that such conduct is necessary to prevent or terminate the other's trespass on or other tortious or criminal interference with either real property other than a dwelling or personal property that is lawfully in his or her possession or in the possession of another who is a member of his or her immediate family or household, or of a person whose property he or she has a legal duty to protect. A person who uses or threatens to use force in accordance with this subsection does not have a duty to retreat before using or threatening to use such force. Now, subsection 2 allows for the use or threatened use of deadly force only if a person reasonably believes that such conduct is necessary to prevent the imminent commission of a forcible felony. Subsection 2 reads, a person who uses or threatens to use deadly force in accordance with this subsection does not have a duty to retreat and has the right to stand his or her ground if the person using or threatening to use the deadly force is not engaged in criminal activity and is in a place where he or she has the right to be. So now that you know what Florida Stand Your Ground law is, what it does, and when it applies, be sure to let us know what you think about it down below in the comments section, along with any other questions you might have. Now, I do want to leave you with one final thought. Just because you have the legal right to do something doesn't mean you should do it. I want to repeat that. Just because you have the legal right to do something doesn't mean you should do it. Sometimes the best way to get out of a situation is to leave the circumstances behind. Walk away from it. Now, I know the law allows you to stand your ground, but I have seen people who are justified in their use of force still get arrested and prosecuted. So sometimes it's better just to walk away. Until next time, stay armed and educated.